Hi, everybody. My name is Kelly O'Rourke Johns, and I am president of IDA UMB. Thank you so much for being here today for our presentation. I'd like to introduce to you Amy Getz, who's the founder of the School Law Center and co-founder of the former Center for Education Law, private firms that focus on education issues. Amy has worked in education law since 1995, first as a staff attorney with the Minnesota Disability Law Center in Minneapolis, then as a complaint investigator at the Minnesota Department of Education, and finally in private practice. She is here today with Andrea Jepson, and who is also from the School Law Center, and they will be making their presentation to you here shortly. I did want to let you all know that you are muted and therefore cannot speak during our session. We have often over 100 people attending these sessions, and therefore, to minimize feedback, we have to mute everybody. However, if you have any questions throughout the presentation, please feel free to type them in the questions area of the control panel there that you have through GoToWebinar, and we will answer them in the order we receive them at the end of the webinar. So I will hand it on over to Amy. Amy?
Thanks. Good evening. Welcome, everybody. This is Amy Getz, and along with Andrea Jepson, we're going to be giving you some information tonight about legal rights and procedures for school supports, geared particularly for students with learning disabilities, although a lot of the presentation applies to students with disabilities of all categories as well. I'm going to start out with the presentation, and Andrea will be taking over about midway through, and she can give a little bit more introduction to her background, but we share a lot in terms of our backgrounds. Both of us worked in legal services for a number of years. Both of us have our own children with disabilities and have worked with the public schools in designing and implementing programs of supports, IEPs, for our own children. And so Andrea's been working with the School Law Center since about June, and is a very dedicated and expert attorney in this area as well. We have information about our contact information here that's coming up on the next screen. You can contact us at this address, this phone number, these email addresses. We're also going to send to Kelly a copy of this presentation. She will post it so that you can access this information sometime after the webinar as well. You can always call us, you can always email us, and ask for particular guidance on any legal problems that you are facing, any legal questions regarding school law issues that you have. We welcome your contact. So there are many sources of student legal rights. And in a hierarchy, of course, we start with the United States Constitution, the 14th Amendment, and its two major provisions that protect students with disabilities, the Equal Protection Clause and the Due Process Clause of the 14th Amendment. Secondly, Section 504 of the Rehabilitation Act of 1973. Third, the Americans with Disabilities Act. Fourth, the Individuals with Disabilities Education Act. Fifth, the Minnesota Human Rights Act. And sixth, the Minnesota Pupil Fair Dismissal Act. We're going to give you some information about each of these sources of legal rights. So first of all, the United States Constitution, the 14th Amendment, equal protection. That clause guarantees all United States citizens equal protection of the laws. So whatever laws exist in terms of federal protections apply equally to all citizens, regardless of status. That's the essence of the Equal Protection Clause. A couple of cases that actually were the genesis of the Individuals with Disabilities Education Act were grounded in the Equal Protection Clause of the 14th Amendment. The first is the Park case out of Pennsylvania in 1971, where their state law said that kids who had not attained a mental age of 5 years could not be admitted to the public schools. And parents and lawyers challenged that state law, and that resulted in a consent decree, a settlement with an agreement that all children would be enrolled in school regardless of attainment of mental age. And so the essence of the agreement and the essence of the claim was that all children were not getting equally protected under the law that gave children the right to enroll in school. The next case was the Mills case from the District of Columbia in 1972. And what was happening there was that schools were expelling kids and refusing to enroll the students who were having disability-related behaviors. And that actually went to a court decision, and the court there decided that that practice violated the Equal Protection Clause of the 14th Amendment. Again, kids with behavior-related challenges were not getting equal benefit of the protection of the right to attend schools. So Park was kind of the closed schoolhouse door, and Mills was the revolving schoolhouse door. And both of those practices and laws violated the Constitution's guarantee of equal protection. The second provision of the 14th Amendment that applies is the Due Process Clause. And what that clause says is that all United States citizens get to have a process, and that a process is due to them before government deprives them of life, liberty, or property. And the courts have long recognized that education is a state-created property interest. The best example of a due process case is Goss versus Lopez. And that was a case that went to the United States Supreme Court in 1975 that challenged parents, again, and all the good law that has been created in this area has been because parents have found lawyers and have pursued claims and gone to the courts. That Goss versus Lopez is just the next in line in terms of good civil rights advancements coming with parent effort to make changes for their children. There, the challenge was against this Ohio law that permitted short-term suspensions for 10 days without any kind of hearing. The court there, up to the Supreme Court, the court recognized that there's a right to education that is embedded in state law, and that citizens cannot lose that right without some kind of fundamentally fair procedure. There's some really good language in that Goss versus Lopez case that I continue to return to because we see in our practice still so much in terms of disciplinary exclusions, children losing the right to be in school for misconduct. The court there recognized that misconduct charges, just being charged alone, having a claim leveled against you that you have engaged in misbehavior at school, that can have some very serious consequences. Children's reputations are damaged, their educational opportunities and their employment opportunities both can be impaired. So the court in Goss determined that short-term suspensions, they define those as 10 days or less, have to have due process. There's a process that is due. And that process they laid out was that students are entitled to some kind of notice of the charge, an explanation of what the evidence is that is against them, an opportunity to respond, and that all that has to happen before they're removed from school unless there is a showing of immediate danger or a real threat of disruption. The court went on to say long-term removals, and they defined those as being more than 10 days, may require more formal procedures, and there they were referring to additional protections like the right to counsel, the right to call witnesses, the right to confront and cross-examine witnesses. And we'll talk a little bit later about the Pupil Fair Dismissal Act in Minnesota, and it, like most other states' disciplinary laws, has embedded these due process procedures both with respect to short-term removals, suspensions, and long-term removals or expulsions. The next law we're going to look at is Section 504. Justice William Brennan said about Section 504 that this quote, that really our society's accumulated myths and fears about disability and disease can really be as disabling as the physical limitations that flow from impairment. And he was saying that about Congress's acknowledgement in Section 504. And Section 504 is the section of the Rehabilitation Act of 1973. It's a civil rights law, and at its essence, it prohibits discrimination on the basis of disability. It applies to schools that receive public funding. It requires equal access to education and benefits, and so covers any recipient actually of public funds, so preschools, elementary, secondary, post-secondary schools. The linchpin of the trigger to coverage is the receipt of public funding. Its declared purpose is to ensure that students with disabilities have access to education and benefits that are equal to that afforded to students without a disability. And so that the purpose is to make sure that students with disabilities get to participate in and benefit from school services and programs. The eligibility is defined in 504 by reference to the term handicapped person, and that still is the definitional term. And it's someone that has a physical or mental impairment that substantially limits one or more major life activity, or has a record of an impairment, or is regarded as having an impairment. So substantially limits, it seems like a pretty high standard, and the courts have really looked to three factors to determine whether or not a substantial limitation is present from an impairment. And really it's about how, what type of impairment, how severe it is, how long it will last, and really how it impacts someone. And long-term impact is really kind of what the courts look at. You have to be a qualified handicapped person, and know that there are differences depending on what level of school you're talking about, what type of recipient you're talking about, in terms of whether you're a qualified handicapped person. When we're talking about elementary and secondary education, you simply have to be of an age when services are provided, or you're of the age when there are mandatory services, so you're a school-aged person, or you are eligible under IDEA, and so that would extend eligibility up through age 21, which is the IDEA upper age limit. And that's different than, for instance, in post-secondary school. In post-secondary school, being a qualified handicapped person involves an analysis of whether you meet the qualifications for the program that you're applying for or you're attempting to engage. So know that there's a different standard. The responsibilities under Section 504. And these apply then, of course, to every public school, elementary, secondary, every post-secondary school that gets public funding, every preschool that gets public funding. And the receiving public funding analysis doesn't necessarily have to be direct. The courts have held that a number of what we might consider rather indirect ways of receiving public funding are good enough to make the, to make the connection between public funding and these responsibilities, like receiving money for lunch programs, receiving money for transportation, receiving money for books. So it doesn't have to be that an entity has to be completely dependent on federal funding in order to have duties to comply with Section 504. And among those duties are to develop a system so that you're in compliance with 504. You have to have a coordinator. You have to notify parents of what your responsibilities are. And you have to provide written assurances that you don't discriminate. And every school in Minnesota does that annually to the Minnesota Department of Education. Every school has to develop a system to address any dispute. They have to develop grievance and hearing procedures. Now, these are not very often accessed. I think in Minnesota there's been one Section 504 hearing since 1973, one that I know of. So they don't happen very often. They don't happen very often for a variety of reasons. Part of that is that the procedures that are adopted are not very definitive. There are not very clear rules of engagement in terms of what the process should be for a hearing. And in many respects, when IDEA, when the Individuals with Disabilities Education Act was passed, Section 504 became somewhat subsumed by it and became somewhat obscure in terms of people recognizing that 504 was intended to remain distinct and viable and separate from IDEA. And we'll talk a bit more about the interplay between those two laws in a bit. Finally, every school has to assure that children that have a disability are fairly educated. So there's a process that is required under 504, and that process involves much of the same processes that are much more clearly defined, much more clearly articulated in special education law, IDEA. But 504, like IDEA, requires that schools identify potential students, and identify means essentially what we know as child find in IDEA, that the schools locate and identify, locate and offer an evaluation to locate and suggest that children may benefit by an evaluation to determine their eligibility for services and protections under Section 504. So that, of course, involves evaluating for a disability before any placement. It's required under 504 that an evaluation be provided, and placement, what is meant by that term in this law is before the provision of services, before the implementation of a Section 504 plan, before the provision of special supports, before the provision of modifications or accommodations. And this is a feature unique to 504, so I want to emphasize it, before any change in placement, students that are eligible for protection under 504 are eligible for another evaluation. And so this is one of the protections in 504 that is very important and one to remember. And it's clear that what was intended here is that changes in placement are so serious that we ought to be sure that indeed a child's needs have changed, and that we have a basis in evaluation before we make a determination of a child's need to change placement. And of course, the provision of a free, appropriate public education is the other part of the process that's required. 504 includes the provision of regular education, special education, and related aids and services. Requires that all decisions are made by a group of knowledgeable people. And that's what the regulations define as the team of folks that make a decision. Note that the big distinction here between 504 and IDEA is that a group of knowledgeable people could be defined, and we see schools defining it all the time, as a group that somehow doesn't include parents. Now, I can't imagine that a group of knowledgeable people who are discussing and deciding things as important as a child's education could exclude parents, but parents are not specifically identified as required members of that group of knowledgeable people. As an executive branch enforcement mechanism, the Office for Civil Rights enforces Section 504, and in Minnesota we turn to the Region 5 office in Chicago, and Section 504 is also, though pretty irregularly, pretty rarely, enforced by the courts. There's not a lot of case law that has developed around Section 504 for a variety of reasons, not the least of which is what I referred to earlier. Once we passed special education law, we kind of assumed that 504 was subsumed by Section 504, and in fact the United States Supreme Court thought that. In 1984, they held in a case called Smith versus Robinson that Section 504 and IDEA were really two sides of the same coin, and that if you brought a claim under IDEA, you were done. There was nothing left of 504 that you could pursue. And Congress reacted to that decision by correcting the United States Supreme Court in a bill called the Handicapped Children's Protection Act of 1986, where they said, oh, that's wrong. That's not at all what we intended. And then they amended the IDEA to add a provision that says nothing in IDEA precludes or prohibits students from maintaining claims under Section 504 of the United States Constitution or any other law that protects the rights of, any other federal law that protects the rights of children with disabilities, except that before you can bring such a claim to a court, you have to exhaust the procedures that are set up, these administrative hearing procedures set up for students and families to access to get relief under special education law, under the IDEA.
May I add something?
Sure.
Well, this is primarily for practitioners, but while 504 sort of went fallow in an education setting, 504 is a law that is applicable in where housing providers are concerned, if the provider is a recipient of federal funds, and really any other organization that accepts federal funds. And so there has been a lot of development in 504 in other contexts. And historically, in the area of employment law, they've tended to borrow from housing, and housing isn't as traditionally borrowed from employment law. And there's really no reason why practitioners who are seeking to, in some sense, revive 504, why they can't look to the application of 504 in other contexts.
Yeah, that's right, and that's a really good point. And we, as attorneys that practice in this area regularly, are very frustrated with the low level of adequacy that hearing officers and courts have decided is good enough to pass muster under special education law. And we are constantly bemoaning the fact that hearing officers and courts turn to an old United States Supreme Court decision called Rowley from 1982 that specifically rejected the equal participation and equal opportunity and equal benefit standard at a time when Section 504 was in effect. It wasn't even mentioned in that case. That was the standard that was adopted by the district court, the Court of Appeals below, that was reversed by the United States Supreme Court. And this was the same United States Supreme Court that decided that Smith versus Robinson case I was just talking about, that said, oh, these are the same laws anyway, that Congress had to correct. So we are constantly looking at cases because we think that Section 504 does have a distinct and unique place and ought to be litigated more. More claims ought to be brought under this very important, more equalizing standard than IDEA. A good representative case of Section 504, one of the few cases where 504 is actually litigated and results in a positive outcome, was a case from our 8th Circuit, MP versus New Prague Public Schools, where a young man with schizophrenia that was not disclosed to his peers at school, or his teachers, frankly. His mother brought medication into the school nurse, who said, oh, this is MP's schizophrenia medication. And there were other students in the nurse's office. And so soon his condition and news of his condition went flying through the small New Prague school that he was in. And he became the target of a lot of harassment by his peers on the basis of his disability. His parents complained chronically about the treatment, the mistreatment, the harassment, the bullying that he endured, to school officials who virtually ignored those complaints. The school did nothing to change his 504 plan. They made no investigation into that harassment. They offered no corrective or protective action, which is their duty under discrimination law when students are subject to peer harassment on the basis of a protected class. The school promised that they would transport the student to a new school if only the parents would take him across the school district lines and enroll him in the next district. And then when they did that, they reneged on that promise. The court here determined that disability harassment was the same kind of protected class discrimination as the courts were used to recognizing in instances of sexual harassment. And so applied that standard, which was great, one of the first cases ever where a federal court did that, and determined that when the parents made complaints to the school and asked for help about the harassment that ensued and were ignored, that bad faith or gross misjudgment certainly could be inferred and could be proved under those facts, because bad faith and gross misjudgment is a standard that has been engrafted onto the proof of Section 504. Another, we think, problem, but really it's about getting to intentional discrimination and intent to discriminate. And so the courts require that students and their families prove intent in that they call bad faith or gross misjudgment. But you know, to their credit, the court recognized that when parents call and complain and ask for help and are ignored, that certainly is an instance where we could call what school officials do bad faith and gross misjudgment. So the 8th Circuit Court of Appeals reversed the federal court's dismissal of the claim and remanded the matter for trial. And the trial ensued. There was a trial by jury, and the student was awarded damages. So that was a great success story. And it took many years to litigate. Next, the Americans with Disabilities Act. So the ADA has been described by some as Section 504 with a punch. It was really meant to emphasize and enhance Section 504. And it was amended in 2008 to expand the protections for people with disabilities, which really was intended to make it easier to be protected under the ADA. And it overturned a series of Supreme Court interpretations that were very restrictive. Essentially, they were the mitigating circumstances cases where the court said you're not even entitled to protections under the Americans with Disabilities Act if there are mitigating circumstances that that relieve you of the impact of your disability. So you're not entitled to protections. There was one case that was a pilot who, with glasses, was no longer a qualified handicap person. Or there was a person, I think, with I think diabetes, who with insulin could function. And so Congress decided that those interpretations of the Supreme Court were wrong and changed the law to emphasize that that's not what they intended. And they intended for people to be able to get the protections on the Americans with Disabilities Act without reference to these mitigating circumstances.
And expanded the application of disability laws as well. So the ADA is going to cover private schools as places of public accommodation where 504 wouldn't be otherwise applicable.
That's right. That's right. There was a really interesting case that was just, certiorari was just denied by the United States Supreme Court a couple of weeks ago. So this is hot law. Breaking news. KM versus Tustin Unified School District. The Ninth Circuit Court of Appeals decided last year that when school districts comply with IDEA, it doesn't necessarily mean they have established compliance with the ADA, and that the standard for meaningful access to education benefits under IDEA does not preclude claims under the effective communication provisions of the ADA. There, a deaf student was looking for CART, a type of transcription services that would permit her to read text when instruction was given verbally. And the court below, the federal court below, the Ninth Circuit, determined that if the school met the IDEA standard, that was good enough. Kind of like the Smith versus Robinson United States Supreme Court. These are, two sides of the same coin. Not so, said the Ninth Circuit. These are viable, distinct claims. The ADA has a different standard for effective communication, and it is not subsumed by the IDEA. And the Supreme Court just denied the school district the appeal. So that Ninth Circuit decision stands, and we see it as yet another signal that heading into the direction of breathing life into Section 504 and the ADA is a necessary complement to the established law under IDEA. So that KM case from the Ninth Circuit gives us this guidance, that the ADA requires more than just accessibility. It requires equal accessibility under the ADA as long as there's no undue burden or fundamental alteration of the program. Public schools have to comply with both, and this is the language from that decision. The IDEA coexists with, but does not swallow, the Americans with Disabilities Act. Next, we're going to talk about the Individuals with Disabilities Education Act, the IDEA. This is really the area in which our practice focuses most heavily, and which you in the audience are probably most familiar. Requires schools to provide specific, unique, and individually tailored educational services to eligible students with a disability. It's been in place since 1975, though in Minnesota we had special education law before the federal law came into play. It ensures due process and equal protection. It was Congress's way of responding to the Mills and Park case in a way that relieved the public schools of having to face down class action after class action in the federal courts. And what they gave to schools in exchange for being relieved of facing down these class action claims in the federal court was an administrative hearing process. And so IDEA requires what's called exhaustion of administrative remedies. You can't file a direct claim in a court. You first have to go through an administrative hearing process. It's meant to be less formal, less adversarial, easier to access. And the thinking is it gives the local school district the first opportunity to fix the problem.
How's that gone?
Oh, we laugh because it's
a little special ed law humor.
It doesn't go very well.
No, it doesn't.
The hearing system has many challenges in Minnesota, in particular, and across the country. It varies, I think, in terms of how it fares. And so we work very hard at finding solutions to the problems that our clients face without having to go to an administrative hearing. And often it requires appeals, and it requires correction of hearing officer orders in order to get it correct, in order to get the law right, in order to get the student the relief to which they're entitled. Federal funds are conditioned on compliance. So states don't get federal funding. Federal funding doesn't pass through to local school districts unless everybody complies with the law. At least that's the theory. There are 6 major principles of the idea. First, free appropriate public education. Second, timely non-discriminatory evaluation. Third, individualized education program. Fourth, it happens in the least restrictive environment. Fifth, it occurs through a cooperative team process with parents. And sixth, there are procedural safeguards. We'll talk about each of those in turn. But here's a chart on the process. So of course you start with a referral for an evaluation, you go to an evaluation through eligibility determination, then you develop the IEP, then you determine the placement in which the IEP will be implemented, provide instruction, annual review is required, and then you go back to evaluation. And with annual review, I think you have to add and revision. So, you know, when you review an IEP, if a child is not making expected progress, if it is not going as people think it ought to,
Oh my God.
then you have to review and revise the IEP. Okay, so evaluations.
Sorry, I have to recover from that terrible thing that just happened.
Okay, so school districts must, this is the federal law, they must identify and appropriately evaluate any student within the district, and we're talking now birth through 21, known or suspected of having a disability. It's not that they have to know that a student has a disability. That's what the evaluation is about. It's that they have a basis to suspect a disability, and a basis to suspect that the student needs special ed and related services.
Ms. Gatz, I have a question.
Yeah.
I actually was going to do a little research on this the other day. I'm interested in knowing if you can tell us anything about, I truly don't know the answer to this question, what it means to suspect a child of having a disability. Is there any case law that describes what that means?
Yeah, that's a good question. You know, my first thought goes to the pre-identified students who also can assert protections under IDEA and the standards that are established there, because I think that's a first good guide. And you know, there's a provision in the IDEA that says even if you're not identified but you should have been, you're entitled to assert the protections under the law when you are facing discipline as a result of and you think it's related to your disability, and you want to assert a claim that you should have been identified before. And there, the students who are recognized as those entitled to assert the protections are those where the school district has been asked to provide an evaluation, where someone has expressed a concern about a child's academic performance or behavior to a person in authority, or there's a concern about a pattern of behavior that's expressed to a person in to a person in authority. And I always look to the disciplinary reports that are reported to principals, for instance, because those are often a rich source of that kind of evidence. you know, failing grades. It's the kind of common sense, I think, red flags. Struggling children, failing grades, poor grades, kids who have the capacity to learn but aren't learning, kids who are not engaged, kids who are not coming to school, kids who are having patterns of behavior problems, kids who are having emotional dysregulation problems, kids who are having attentional problems, executive functioning problems, all the kinds of things that we are getting better all the time at training teachers to recognize as indicators of a potential disability. Those are the things that ought to send up a red flag and trigger a suspicion that a child ought to be evaluated. And in the end, it's the evaluation that gives us the answers.
I have a question for you, Amy. So is the evaluation that a school provides the same as something that's done through a private evaluator?
That's a good question, and the answer is no. Those are totally separate things, and you know, oftentimes school districts like to tell parents, yeah, we're concerned about Johnny, maybe you should check that out. And really that is not the right answer, because it foists off onto parents the responsibility that really is the school's responsibility. It is the school's responsibility to do the evaluation and not the parent's responsibility. And if a school thinks, for instance, that a medical diagnosis is necessary in order to decide whether or not a student has a disability and a need for special education, then it is clearly the school district's responsibility even to provide that medical diagnostic evaluation. So a common myth in special education law that parents ought to go and find their own evaluation. Also, if parents go and get their own evaluation and they bring it back to the school, the law is that the school has to consider, but need not necessarily adopt, the conclusions or recommendations of the outside evaluator, because often the outside evaluators are applying different standards, medical standards, not educational eligibility standards. It is the school district that must apply educational eligibility standards, and they ought to take into account, in fact, they are required to take into account information provided by parents, including outside medical information. So always a good idea to bring it to the district, ask them to take it into consideration as a part of their own educational evaluation. Okay, so the evaluation has to be individualized. Can't be a standard cookie cutter approach, has to be comprehensive. The law says we have to evaluate students in every suspected disability. Evaluations have to be planned by a team of people, including parents. Evaluations have to seek parental consent. So before an evaluation, schools have to ask parents for consent. Before an initial evaluation for special education can proceed, there must be affirmative parental consent. Without parents giving written permission, schools can't proceed with an initial evaluation. Subsequent evaluations, parental consent, subsequent reevaluations. So once a student is eligible for and receiving special education, and every 3 years at least, schools have to reevaluate students. When schools propose to reevaluate a student, parental consent, affirmative written consent, must be sought, but is not required before schools proceed. Parents must, under state law, object within 14 calendar days of receipt of a proposal to reevaluate their child, or their consent is presumed. And again, in Minnesota, evaluations must be completed in 30 school days or less from that point in time of parental consent. Minnesota has long required, decades we have had on our books, a requirement for what are known as pre-referral interventions. And they are essentially what we now know as kind of tier 1 interventions in the response to intervention model. The law requires 2 documented research-based pre-referral interventions in academics or behavior before there's any referral for an evaluation. And the results have to be supported by data and have to be documented. Oftentimes we hear that there are pre-referral interventions, and they consist of things like moving Johnny to the front of the class or talking more loudly or something else. But rarely do we see documentation and data, and rarely do we hear about the research basis for the interventions. But this is a very important, I think, provision of legal protection that parents ought to know about and insist upon, because really the response to intervention, from our view, that the framework of it is a good idea. If we can give students more intensive interventions in the regular ed environment, different kinds of instruction, and they fare well, then everybody's a winner. The pre-referral intervention requirement is very specific, that if a need for evaluation is urgent, that requirement can be waived. So it doesn't have to hold up moving forward if a child really needs us to move into evaluation quickly. And the law is very specific that it cannot be used to deny or delay a special ed evaluation.
Amy, can I ask, what if a school advises that the external evaluation won't qualify for IEP and told the parents to go find another doctor to qualify under another category?
Yeah, it's kind of the same answer. The onus is on the school to do the evaluation. If the parent first went and procured a private evaluation and dutifully returned it to the school, actually beyond the call of duty, returned it to the school, because remember, that's not the parent's obligation, and it's not good enough for the school, my response to the school would be, well, then you should do your own evaluation. And if you need another kind of medical evaluation, then you should produce it yourselves, because really that's the school's obligation. I would be urging parents not to be running from pillar to post and to be sent back and back and back to a private provider to produce something that they're not even sure what's being looked for. So I would put the onus on the school to identify what it is you're looking for, and who can you produce that will provide the information we need.
If someone has an IEP for a particular disability but denies an IEP, essentially services for dyslexia, say, but they also have an IEP for speech or something else, the school can essentially enact a sort of use it or lose it type of, we've heard of this before, where services, the parent has said, I'm not going to use the services that the school provides, and therefore the school says, after a certain period of time, you will lose this IEP. Is that correct?
Well, IEPs are meant to be annual in nature, and parents have a right to take the service or deny the service. And if the service is, so parents have to be asked to consent to implement a proposed IEP. And if parents give consent, then the IEP is implemented, the service is provided. If parents want to refuse to accept the service, that is their right. And then they refuse to provide consent to implement. In that situation, the school must remain willing and able to provide the service should the parent wish to reinstate a request, is how I would think about that. So
for a period of time, or is there a particular period of time?
No, no particular period of time. I mean, whenever a child's need for services might arise and the parents might decide that they want to reinstate a request, then that's how I would think about it, a reinstated request. Schools have to stand ready and willing to serve. They can't force a student to take a service that a parent doesn't consent to. So if parent won't give consent, refuses to provide consent to implement an IEP, the school simply stands ready and willing to serve. And when a parent wants to reinstate that request, then assuming the child remains eligible, that is continues to have a disability and a need for special education, then through the process, you know, you'd have to go back through the IEP team process. That service ought to be offered again.
And what if the school is denying the parent the ability for a 3-year reevaluation testing?
Well, under those circumstances where a parent has refused to consent to implement services, they've refused to consent to implement services, so they have a child who's ineligible.
I see.
And so the duty to reevaluate, every other duty flows from the consent to provide service. If you think your child, and again, I think about it as a reinstatement kind of scenario. If you think your child needs services and continues to be eligible, even if you have previously refused to provide consent, the parent's right is to request a new evaluation, a new provision of service. So it would really be regardless of the 3-year passage of time. I don't think that that's the kind of construct I would think about that scenario in. Okay. Okay, so let's talk about the specific learning disability category of eligibility in particular, because we're assuming that most folks who are participating tonight are most interested in this category of eligibility. It's one of the 13 categories that are identified by federal law. We have given you the federal law definition here. Disorder in one or more of the basic psychological processes involved in understanding or using language. And it can manifest in an imperfect ability to listen, think, speak, write, read, spell, or do mathematical calculations. The term specifically, quote, includes such conditions as, and you know, it's always interesting to me. I've been doing this 20 years and I read the law and I read something new on it. Every time I read this again, I thought, brain injury, really? Brain injury is included in the term SLD at the federal level because we treat it as a separate category. A traumatic brain injury has its own criteria under Minnesota special education criteria. Minimal brain dysfunction, perceptual disabilities, dyslexia, and developmental aphasia. And dyslexia, we hear all the time from parents who say, my child has a diagnosis of dyslexia and needs some help at school, and school's response is, we don't recognize dyslexia, which is why I wanted to put this direct quote from the federal law into this presentation, because the word is used in federal law, and schools just don't get to choose not to recognize a condition that is specified in the federal law as included within this term. The term does not include, and this is also part of the definition, these rule-outs, learning problems that primarily result from visual, hearing, motor disabilities, mental retardation, they still use that term, emotional disturbance, or environmental, cultural, or economic disadvantage. In essence, the child has to be not achieving adequately for age or to meet state grade level standards with appropriate instruction, and in one or more 7 areas, and I've got this part of the law bookmarked because I'm always going to it, because, you know, we think of reading, and sometimes we think of written expression, and sometimes we think of math, but we don't think of reading fluency necessarily, reading comprehension, the 2 parts of math that are recognized, math calculation, math problem solving. And I never see students who are identified with a learning disability under oral expression or listening comprehension, though we see a lot of students who struggle in those areas. And so when we go back to the evaluation table with districts, are pressing them to do an evaluation and look specifically at this. So good to have on hand that list. Still part of the federal definition, the child has to be not making sufficient progress to meet age or state grade level standards using a process based on a response to scientific research-based intervention, or must exhibit a pattern of strengths and weaknesses in performance achievement or both relative to age, state, grade level standards, or intellectual development relevant to identifying an SLD. So this is the new definition. This is the new definition that permits states to identify kids with learning disabilities based on either the traditional discrepancy model, which is this screen here, captures the traditional discrepancy model. The previous screen captures the response to intervention model that is now emerging and will soon likely overtake and replace entirely the discrepancy model. Okay, so, and I say that because there's this evolution toward RTI. Since 2004, IDEA has prohibited states from requiring the traditional discrepancy model. The law now says that states must permit the use of a response to intervention approach, and that states may permit other research-based methods for identification. So Minnesota followed this requirement. Soon after IDEA 2004 was enacted and promulgated what is now our specific learning disability rule that incorporates the response to intervention approaches. So it is now defined by these state rules, and these are we've laid out for you here the basic tenets of the state rule on SLD. Must interfere with acquisition, and again, it's always helpful to look back at the law and the words of the law, because our rule breaks this down in great detail that in ways the federal law does not. It looks at acquisition, organization, storage, retrieval, manipulation, or expression of information, all of those areas. The child is not learning at an adequate rate, again, for age or grade level standards. It has to primarily affect academic functioning and can't result from other disabilities, limited English proficiency, or a lack of appropriate instruction, kind of similar to the rule-outs in the federal law.
Does that mean that really bright kids can be dismissed by the school if they're meeting performance at the 50th, 60th percentile as being good enough?
That's a very good question. And we often get calls from parents of very bright kids who are told your child is not eligible, and therefore we won't do an evaluation. When parents request an evaluation, a special ed evaluation, it is not absolutely mandatory that the public school provide the evaluation. But the creation of some standard, 50th, 60th percentile of performance, is, as you will see and as you can see from what we've already laid out of the federal law, nowhere embedded in the law. So the question then becomes, can a school district impose a standard that limits access to eligibility and services in a more restrictive manner than federal or state law? And the answer to that is no, they may not. And so that really becomes the rub in terms of children who are performing adequately. And often we hear the question framed in terms of the school district refuses to do an evaluation of my child because they say she's performing adequately in her classes. She's receiving passing grades. She needs to fail before we can do an evaluation. And the traditional discrepancy model has been referred to as the wait to fail model, and that's the model that's has fallen into disrepute, really, and is being replaced by this RTI criteria that does not wait for children to fail. And more importantly, there's a specific federal regulation that says that children who are receiving passing grades and are being promoted from grade to grade are not necessarily ineligible for special education. So passing grades and passing from grade to grade, those those circumstances are not determinative of eligibility or more pointedly ineligibility for special education, nor are they determinative, those factors, of whether or not a child's receiving a free appropriate public education. So just because a child's receiving passing grades, just because a child's passing from grade to grade, once they're in the special education door, does not mean that they are receiving a free appropriate public education. And it certainly is not a reason to keep them from getting an evaluation. Okay, so the state RTI criteria mostly mirrors the federal requirements. Gives us a little bit more detail. So this inadequate rate of progress has to be measured over time based on scientific-based interventions, and 12 data points over at least 7 weeks. So that's the standard embedded in Minnesota criteria. There are 4 indicators of rate of progress being inadequate: improvements minimal and not likely to result in reaching age or grade standards, progress not likely to be maintained when supports are removed, performance on assessments fall below age or grade standards, and achievement is at or below the 5th percentile on one or more valid and reliable tests of achievement. This last feature has concerned us since its passage, and we are hearing from parents out in the field who are telling us that they are being told that essentially, so long as your child is performing above the 5th percentile, we're not going to worry about them. And that 5th percentile language can come from nowhere but this new feature of the new eligibility criteria. If you're hearing that, that's not what this provision was intended to do. It's not what this provision tells us that we ought to be doing, and it's a significant problem, and you should be contacting folks at your district and complaining about it. You should be contacting folks at the Department of Education and complaining about it. You should be challenging that incorrect conclusion. So here's a model of the 2 different ways in which now Minnesota rules get us into the SLD eligibility door. And this comes from the technical manual that was put out by the Department of Education. So it's A, B, C, or A, B, D. So A and B are the same: inadequate achievement, response to appropriate instruction, basic psychological processing. C is the severe discrepancy. That's the old traditional model on the left. And by that, and the discrepancy, we mean between intellectual ability and academic achievement. And D on the right is this inadequate rate of progress over 12 data points and 7 weeks using repeated measures. Documentation is required in 6 areas in order to find a student eligible under special education. Has to include observation in the learning environment, documenting academic performance and behavior, a statement of the existence of a specific learning disability, a basis for determination, educationally relevant medical findings, the criteria under one of those 2 models that we just looked at. If it's the RTI model, the instructional strategies used, so this has to be documented. What is referred to as child-centered data collected, parental notification, strategies to increase the rate of learning, and a parent's right to request evaluation, all of it documented. Then each group member has to certify in writing that they agree with the conclusion, or they submit a separate statement of their conclusions. Each school district must have a plan to identify students with a specific learning disability, and that has to be contained in their total special education system plan. That's something that is filed annually with the Minnesota Department of Education, maintained in every school district. You can ask to look at it if you have questions about that, and they have to produce it for your review. And that plan has to detail the specific research-based approach, what is used, what parental notification and consent will be used, and procedures to ensure fidelity of implementation, and how each school district plans to train its staff. All right,
All right.
I'm gonna turn it over to Andrea now.
Ms. Getz, you're a hard act to follow. I trust you'll do a better job of manning the slides than I did.
I'll
All
try.
right, I'm sure you'll be successful. All right, well, let's talk about some eligibility myths. The first being that dyslexia is not a recognized disability. We've already covered that it's a specifically recognized disability. I'm not sure where that idea would come from, other than I think the challenge that all folks who have hidden disabilities struggle with, which is if you don't look like you're disabled, then you must not be disabled, and it's a challenge that a lot of folks have to. Go ahead.
I'll tell you what I hear a lot, and that is, that's a medical term. That's a medical
interesting.
diagnosis, and that doesn't govern us here. So we
Yeah.
don't want to hear about that.
We also hear a lot too that educators believe that dyslexia is overdiagnosed. You get that quite a bit, and so they feel that it's a very vague, large parameter that people use, that diagnosticians apparently use, and so they don't recognize it. Can I ask you something really quickly while you're right here? Is what if can an IEP state the term dyslexia? Can a parent require that it is utilized in the IEP?
I'd say yes and no. Can it state? Absolutely, it can state. And if I were a parent of a child with that diagnosis, I would say it ought to state it. It ought to describe what it is. It ought to, so that when educators pick up that IEP, they know what it is we're talking about, and it ought to describe the effects of that condition on this child's learning. Can a parent require that it be included? Probably not.
Thank you. And your thinking is, I'm not entirely clear about the question. This is somebody who is speaking about eligibility categories.
Specifically, their educators are not recognizing dyslexia specifically.
Just refusing
They're
to
just saying SLD, and so they feel that if it was specified in the IEP, then they'd have to remediate it specifically.
Interesting. All right.
You know, there's always more than one way to skin a cat, I think. And you know, if they don't want to use the term, they can use descriptive terms to identify the ways in which whatever we're not going to call it affects the child's learning and what it is they need.
I always say, call it Joe.
That's right.
Yeah, she has Joe.
There you go. The second eligibility myth, that parents are responsible to trigger the child find. We've addressed that already. That is a school district obligation. The parents must provide medical diagnoses. If medical documentation is to be acquired, then it is the school district's obligation to provide that medical documentation. And the children getting good grades are ineligible, and the law is very specifically identified that good grades alone, or the presence of good grades, doesn't put a child in a position of not qualifying for special education services. Oh, that's okay. There you go. So your individual education plan has got to include a written statement that includes the student's present educational level, measurable goals, and there's really an intersection between these two requirements that I think sometimes is neglected. So in order to develop a measurable goal, you really do have to have a measurable present educational level. Otherwise, you're not in a position to be able to measure progress. And it's not uncommon for us to see IEPs that do not use concrete descriptions of the present educational level. Specific educational services to be provided. Needed transition services. Needed transition services are, unfortunately, sometimes the unwanted stepchild of the IEP. But transition services, I think increasingly we appreciate, are extremely important for children who have special needs, because really the whole point of special education is ultimately you've got to produce human beings whose capacity for independence is as well developed as it can be. And then criteria for progress evaluation. Okay. So the right to a free, appropriate public education, that right includes, or I'm sorry, it applies to, and is held by students who are suspended or expelled. A child who is suspended or expelled is still entitled to the special education that they're otherwise entitled to. Students, regardless of grades or promotions, it's a free, appropriate public education is available in a residential education placement. And a child who is on an IEP has and is eligible for a free, appropriate public education also has a right to assistive technology devices and services.
And all these are features of a free, appropriate public education. So they're components of it.
Absolutely, and that's, I think, really important that you've underscored, because it's not uncommon for us to see school districts ask the parents to provide assistive technology or rely on the parents to provide assistive technology, and it is part of a free, appropriate publication, or I'm sorry, free, appropriate public education, and as such, assistive technology should be free to the student. Extended school year services are an aspect of a FAPE. Extended school year services frequently not explored by an IEP team, and it is something that the IEP team is obligated to consider as a team when they do their yearly review. Non-academic and extracurricular services. The child is, or the issue of a free, appropriate public education is present where the child is participating in non-academic or extracurricular services. Related services like
OT,
thank you, OT, PT, speech, as they are a feature of a free, appropriate public education as well, and access to the general curriculum. So we talked a little bit about Rowley already, and we'll talk a little bit further here. Rowley is a Supreme Court case, and it has sort of held sway over the condition of special education in our country since the Rowley decision was came down. And the court in Rowley declined to really set a standard in terms of what it means to receive a free, appropriate public education, but did identify that a FAPE has been made available when procedures are followed, when some educational benefit is made available, and that's a really interesting phrase. We've talked a little bit about 504 previously and its promise of equal access and equal benefit, and you see in this discussion of what is really sounds like a very minimal standard, some educational benefit, the reason why it's really important to remember that a child who is covered under 504 and also IDEA should be attentive, or the family should be attentive, and the school should be attentive to that child's rights under 504. An individualized analysis, a child who receives all of these components, including an individualized analysis, has had access to a FAPE, as the Rowley Court has said, and then that that schools are not required to maximize student potential, which is a very, very hard, it's a harsh reality that has come out of the Rowley Court, because we're all, as parents, looking to maximize our children's potential.
Let me say something about the individualized analysis. So the court there said that the determination of a FAPE is an individualized analysis, and it depends on a child's potential, their disability, how it affects them. So that's what this term individualized analysis means here, is that the determination of FAPE is individualized as to each child in each case. That's why they said, we're not setting a standard. Every child's case is different, and we can't set a standard. Any standard we would set would be too high for some children and too low for others.
There we go. IDEA defines a FAPE to require an IEP that meets state standards. That's a really important feature, because we've got standards in our state that help us to understand when any student has had any kind of meaningful benefit from his or her education, and children on an IEP are not, they're entitled to, to meet state standards as well. And it gives us something that we can use to measure educational benefit, where the Rowley Court has not provided us with the same guidance. So Minnesota has academic grade level standards that apply to virtually all students. FAPE equals an achievement of state standards, and there is a trend towards Common Core standards across all states, and we think a very good trend.
And Minnesota has English, or language arts is the Common Core standard we have adopted. We have not adopted the math standard because we think ours is higher than the Common Core standard, but stay tuned for developments in that area, and look to what we've already adopted in our state as some pretty good state standards, I think, in terms of creating markers by which it is fair to set goals and objectives in students' IEPs.
Can I just ask a quick question?
Mm-hmm.
What is when does the RTI? Is there like a set date for the RTI model to be established within the school districts?
There is not. The Department of Education has surveyed school districts in Minnesota. The last survey told us 40% of school districts are at some level of implementation, and that some level is defined rather loosely. It can be that they're exploring, can be that they're in early stages of implementation. MDE is doing a yearly survey. The full implementation, I'm told, of RTI takes 3 to 6 years for a cycle, according to the research. There is a bill pending right now in the Minnesota legislature proposed to phase out the discrepancy model, but the caution, I think, has to be you can't take away one model of identification when less than half of the school districts aren't anywhere near full implementation of the other model. So you have to have multi-tiered programs up to speed. The IDEA reauthorization or the education, the Elementary and Secondary Education Act, one or both, may address a timeline for phasing in of RTI. And of course, remember, in Minnesota, we have those pre-referral interventions that have long been required.
All right. Congress declared that the primary purpose of IDEA is to assess and ensure that special education services are effective. And so FAPE must equal the provision of effective services. And that requirement is consistent with Section 504, the Americans with Disabilities Act, and equal protection principles under the Constitution. All right, so methodology of instruction. So this is not a slide that I created, so I'm going to look to you. What I think you were looking for with this only effective methodology is left to the teacher's discretion really is sort of consistent with the bottom bullet, which is the methodology is typically not something that an IEP team is discussing at length or necessarily laying out in an IEP, as long as it's workable. So it's under the provision of or under the purview of the teacher, unless it's just simply not meeting the child's needs, and then the IEP team is taking more control over the methodology that's being used.
Well, that's right. This was important to add because we get so many calls from parents and have so many discussions with parents who are told when they say, my child's just not learning to read. Could we try something different? They are told, oh, methodology of instruction is left to the discretion of the school district. And that's part of a sentence out of Rowley. The rest of the sentence is, in conjunction with the parents and the IEP team. That's the rest of the sentence. But the reality of it is that courts are satisfied letting schools decide how to teach our children. That's what methodology of instruction is, how to teach them, so long as it's working. But when it's not working, even the Rowley court recognized that methodology of instruction is an appropriate subject for discussion and decision by the IEP team, because after all, special education is defined under the law as adapting the methodology.
And IEP teams determine what special education is and how that methodology may be adapted. And it's important for us to remember that IEP teams, the term IEP team is not synonymous with the school district officials, but IEP teams include parents, and it's not unusual for us to hear school districts use that sort of terminology. The IEP team and the parents, well, the parents are part of the IEP team as well.
That's right.
What if, for example, in the case of, in this case, a 504 plan as well, an IEP, a parent is requesting particular accommodations for, say, a MAP test, oral reading or longer time, etc. And what would be the recourse for the parent if the district refuses?
Well, there's a number of recourses. Certainly, you can file a complaint with the Minnesota Department of Education. You can ask for a due process hearing. You can engage in mediation with the school district. You could have a facilitated IEP team meeting. So there are a number of
Dispute resolution.
Right, and I think we're covering that here as we get to the
Conciliation conference.
Yep.
The 5th. Call your special ed director.
Yeah.
You know, go to the top in the district and ask for their help. You know, before I say before you consider any other kind of dispute resolution, because they should be your best friend. You know, often they are people who can make things happen and will make things happen and are very interested in keeping their customers satisfied.
Thank you.
All right, so denial of a FAPE has been identified as occurring when there are procedural violations, and procedural violations deny a FAPE if they impede the right to a FAPE. So a procedural violation is going to be more like, there's a process that's been described that the process unfolds as described. It hasn't unfolded as it should, but technical violations are not going to be a problem if they haven't caused any actual impediment to receiving a FAPE. If they significantly impede parental opportunity to participate in decision-making, parents are the experts in their children's needs, and so they've got to be there and available and able to participate in decision-making processes, and if procedural violations deny or cause a deprivation of educational benefits. Substantive violations deny a FAPE if meaningful educational benefit is denied, if educational harm is caused, and if there's a fundamental failure in the implementation of the IEP. Now, your child has got to be receiving an education and special education in the least restrictive environment, and that means to the maximum extent appropriate to the child's needs, that the child is being educated with non-disabled students. And when a child is removed from the general education classroom, the child can only be removed to the extent that it's necessary to provide a FAPE, and it must be justified in the IEP. And so it is not a good reason to move a child from his or her least restrictive environment, because it is more convenient for the school district to provide a FAPE in another setting, in a more convenient setting. But full inclusion in the end is the default, and we work from that default to a more restricted setting if that ends up being appropriate to the needs of the child. IDEA requires state-of-the-art supplementary aids and services. Those can be as vast and varied as the kinds of disabilities that there are out there, and they must be based on peer-reviewed research to the extent practicable. So as we said before, IDEA prohibits removing students from regular education solely because modifications to the curriculum are needed. Again, inclusion whenever possible. That's the Rowley Supreme Court case. There is a strong congressional preference for integration. The Light case communicated this. And the local educational agency must try to less restrictive alternatives before restrictive placement from Evans, and the student who can be provided an appropriate education cannot be moved to a more restrictive placement, even if it is better. And that's from the Grace case.
And those are all 8th Circuit Court of Appeals cases.
So transition services, we've mentioned these before, very important services. As a practitioner, I've become more and more aware of and have come to appreciate more and more the importance of transition services. And they must be provided during grade 9 until graduation or until a child ages out of special education, and each IEP must include a statement of a child's needed transition services. Transition is an outcome-oriented process, and by that we mean really we're trying to maximize independence. It's an interesting standard because the goal of special education has appeared to have been watered down over time, but the language of the statute is very clear. Transition services are intended to maximize independence towards post-secondary education and training, or through post-secondary education and training, maximizing independence through employment, community participation, recreation, and leisure and home living. The Minnesota legislature has declared that the purpose of special education is to address the students' need to develop skills to live and work as independently as possible within the community. Again, really very, very powerful language. All right, we talked just briefly before in response to the question about conflict resolution options, mediation, which can be an interesting way to address conflict between the team. Frequently what's used is something called shuttle mediation, where you're in one room with people who are there to support you. The district is in another, and the mediator is moving back and forth between the two different rooms and trying to get the parties to come to agreement. Yes, 5 minutes. All right, we're gonna move through it fast. So we facilitated IEP team, conciliation conference, state agency complaints, and ultimately due process hearings. All right, so we're going to try to move through the rest of this pretty quickly, but Thompson we'll just touch on briefly. The most important thing about Thompson, which is an Eighth Circuit case, and we're in the Eighth Circuit, the most important thing for you to know about Thompson is that if you believe that your child has not received a free appropriate public education, it is necessary for you to provide notice to the school district providing those services before you remove your child from the school district, or you'll lose any claims related to the failure to provide a FAPE. And notice, just so we're really clear, is it's a term of art, and what that means really is that you're going to need to ask for a due process hearing. So before you move a kid, really important for you to talk to somebody about what may be required to preserve your claims. Similarities between 504 and IDEA. They both have all of these obligations that you see here: child find obligations, evaluation, FAPE, and least restrictive environment. Residential placement, procedural safeguards, and they apply in non-academic and extracurricular services. The differences are, and this is a big difference, that parental involvement is not required. You're certainly giving your input, you're asking for an adaptation based on the information that you have about your child, but your involvement is not required in the provision of the accommodations or modifications. Eligibility for 504 is based on the federal definition of a quote-unquote handicapped person, and IDEA is driven really by state eligibility criteria. Section 504, the standard is not the same, and there's been a lot of discussion about whether it's more profound, less profound, but the language is substantially limits versus adversely affects. 504 is really about accommodation and modification primarily. It's not about specialized instruction like IDEA, and there are differences in evaluation protocol. Again, we mentioned that IDEA is really about the provision of special education and related services, more procedural safeguards, and more extensive notice requirements. Again, very significantly, Section 504 has no transition planning or services required. Very often, IDEA coverage under IDEA is most attractive to folks because again, these transition services are just so important. No explicit discipline protections under Section 504, and for kids who are struggling because their academic needs are not being met and maybe struggling with behavior as a result, IDEA provides important discipline protections. And Section 504, you are entitled to go directly to file suit in court if that's your decision, and IDEA requires you to go through this administrative procedure first. Section 504, really about bad faith. IDEA intent not really very relevant for IDEA. There is different kind of relief available under Section 504 in IDEA, and as we mentioned before, there's a different complaint system for Section 504 in IDEA. Yankton and versus Schramm, I'll just briefly discuss. It's another Eighth Circuit case. Tracy Schramm was a young woman with cerebral palsy, and the most significant parts, I think, for our purposes tonight about Schramm were that special education services must be provided to a student eligible under IDEA, really, which means that where a child has dual eligibility, and many children do, the school district is not free to opt to serve a child under Section 504 where the child has eligibility for enhanced protection under IDEA. We can just move through this here quickly. The Minnesota Human Rights Act is another law that protects people and students with disabilities. That's okay. It prohibits discrimination on the basis of. You were going to do a better job than I was.
Oops.
That's all right.
Sorry.
That's all right. The Human Rights Act, it covers disabled people or people with disabilities in all kinds of settings, but it's also, its coverage is available to students, covers things like disability harassment as a form of discrimination.
Covers private schools too.
Absolutely covers private schools, and you can make a complaint through the Department of Human Rights. The Minnesota Pupil Fair Dismissal Act is a state law that governs suspensions and exclusions and expulsions.
Maybe we should move through that.
I think we should, and we've talked about it a little bit already. I think.
Interesting case that we talk about. You
Yes.
can read, I think. And,
yes.
And then we have some frequently asked questions. Probably it's about time to wrap up here.
Yeah, we've covered a lot probably of the
Yep.
questions that you have, and certainly we will provide this presentation to all attendees, as well as CEUs for those who requested and paid for them at the beginning. I've been asking questions that people have posted throughout the presentation, so that's why we're sort of running a little bit later than typical. Is there anything else that you wanted to add, ladies?
I don't think so. I think some of the frequently asked questions, if you download the information, there are some good questions, some good information in terms of answers and direction. Again, we have our contact information here throughout the presentation, and at the beginning and at the end. Sorry, I just skipped through the last page. But feel free to contact us. We're glad to talk with folks. And thanks very much.